3.5 years since the attack on the U.S. Capitol. 17 months after Donald Trump was criminally charged by the government he once led and will lead once more. Special counsel Jack Smith's cases against Donald Trump, well, they are coming to a close. Just this afternoon, the special counsel moving to dismiss the federal election case. They also asked a court to dismiss his appeal of Judge Eileen Cannon's ruling, tossing out his indictment of Trump in the classified documents case. The move was expected with Trump's election victory, since it's the Justice Department's policy that sitting presidents cannot be prosecuted. Smith writing in his filing to Judge Chutkan today, quote, "The department and the country have never faced the circumstance here where a federal indictment against a private citizen has been returned by a grand jury and a criminal prosecution is already underway when the defendant is elected president." In other words, criminal defendant Donald Trump got out of his legal troubles by getting elected president. The special counsel making it clear that his request to dismiss the election case has nothing to do with the merits of this case or the evidence he's compiled. Instead, it has to do with a constitutional contradiction that could have serious consequences for the rule of law in this country. Special counsel saying, quote, "The government's position on the merits of the defendant's prosecution has not changed, but the circumstances have. As a result of the election held on November 5th, 2024, the defendant will be certified as president-elect on January 6, 2025, and inaugurated on January 20th, 2025. This sets at odds two fundamental and compelling national interests. On the one hand, the Constitution's requirement that the president must not be unduly encumbered in fulfilling his weighty responsibilities. And on the other hand, the nation's commitment to the rule of law and the long-standing principle that no man in this country is so high that he is above the law." And that is where we start today with former top official at the Department of Justice and MSNBC legal analyst Andrew Weissmann. And with me at the table, MSNBC legal correspondent Lisa Rubin, plus host of the Fast Politics podcast and special correspondent for Vanity Fair, MSNBC contributor Molly Jong-Fast. It is so good to see you all. So, Lisa, not unexpected.
Not unexpected at all. And in fact, you know, I was reminded of the T.S. Eliot poem earlier today because I just kept saying, this is the way the cases end, not with a bang, but a whimper. This is not unexpected. What is unexpected is that Jack Smith is looking to dismiss these cases without prejudice, which of course leaves the possibility that they could be reopened at another point in time. On one hand, Alicia, it could be totally meaningless. One, to dismiss the cases without prejudice means that you're taking a flyer on whether or not they can be tolled or paused while Trump is in office. And of course, there's the other possibility that could render them meaningless, which is that he could just pardon himself. But Jack Smith essentially saying today, I'm willing to take the possibility of a toll. And if you want to pardon yourself, that's on you. You have to do that. I'm not going to let you off the hook that easily. I'm not going to absolve you of that. I'll go as far as dismissing without prejudice because OLC policy requires me to, but no further.
Andrew, what did you read from the without prejudice?
Well, I thought there was going to be no question that Jack Smith, because he is a member of the Department of Justice, was going to have to follow Department of Justice policy. And that, as you noted, Alicia, is that two Office of Legal Counsel opinions within the Department of Justice, one during the Nixon years, one during the Bill Clinton years, said that a sitting president cannot be charged at the time that he is president. So it was no question that this was going to be dismissed. But if you're going to dismiss it, I mean, why on God's green earth would Jack Smith seek to have this dismissed with prejudice, which means the case is definitively over? And why not just take the, as Lisa said, a flyer? Why not take the possibility that it would be dismissed without prejudice and it could be revived later? I do think that there is a big, that's sort of like not surprising. I do think there is an open issue as to whether Jack Smith should have simply waited and not, I mean, what he gets out of this is he gets it much more likely that Judge Chutkan is going to agree that it should be dismissed without prejudice, that it's not gone for all times and all purposes. But at the same token, by Jack Smith doing this and not requiring the new incoming president to do it himself, he's sort of doing, in some ways, the future administration's work for it. In other words, to the extent that there's any political hit, I'm not saying there is or isn't, but to the extent that there's any, why not say, you know what, Donald Trump, if you are going to dismiss a righteous prosecution, you're going to have to do it. We're not going to do it. So it's a trade-off because he's getting a more likely dismissal without prejudice on the same, but sort of more into Molly's field, which is sort of political repercussions. He is in some ways doing the work for the incoming administration.
How do you think this plays politically?
I mean, if people know about it, right? One of the things is we saw all these cases and they never broke through because the media is different, right? It's on podcasts, it's Joe Rogan. So, you know, if it ends up being talked about on Joe Rogan, then people will find out about it. And if it doesn't, then it won't. I mean, that's the sort of siloed effect we're in right now.
There was a piece from the Smith filing that I thought maybe answered part of Andrew's analysis and question. I'm going to read it to you, and then you tell me if you agree. The special counsel's office therefore sought Office of Legal Counsel's guidance on whether this case must be dismissed, or whether the pending superseding indictment against the defendant could be held in abeyance until he is no longer immune from prosecution. OLC concluded that its 2000 opinion's categorical prohibition on the federal indictment of a sitting president, even if the case were held in abeyance, applies to this situation where a federal indictment was returned before the defendant takes office. I mean, does that mean he asks Garland's DOJ to weigh in on this? What does that tell us?
That it's exactly what it means. It means that they're in unprecedented constitutional situation and that they need some guidance from OLC, which many people understand as sort of an in-house counsel for the Department of Justice on weighty constitutional questions. I think the part of it that's interesting is Jack Smith is saying in this filing, OLC not only told me I have to get rid of this, but it told me I have to get rid of this before he's inaugurated. And not, Jack Smith is making the determination on his own, not on December 20th at 11:59 a.m., but now. So then, Alicia, that begs the question, why now? I have one thought as to why that might be, sure. And it has to do with the special counsel regulations. Noting, of course, that the Trump folks think that the special counsel regulations are unconstitutional and Jack Smith's very occupancy of that role is not proper. The special counsel regulations say that the special counsel should deliver a report to the Attorney General at the conclusion of his or her work. What does it mean to be at the conclusion of your work? I mean, Andrew knows better than anyone. One way you get to the conclusion of your work is you sort of transfer the cases that you're currently working on to other branches of DOJ, like the Southern District of New York or Main Justice. But maybe Jack Smith's take on this is, for me to get to the conclusion of my work, given that nobody else in the department is going to take up these cases, it means I have to dismiss them before I can deliver a report on my investigation to Merrick Garland that I intend to have see the light of day.
So, Andrew, I want you to weigh in on Lisa's analysis. I also want to know if you think we ever get to see that report, if it ever becomes public.
Yeah, I mean, I think that's really very much, we're sort of dancing on this head of a pin on sort of like, should it be dismissed with prejudice or without prejudice? And will it make any difference? And should he have waited to have the DOJ do it under the Trump administration versus doing it now? All of that is sort of, it's like, this is like the kind of thing Lisa and I like talking about sort of off camera, and it's super nerdy. But I think, Alicia, in many ways, the key issue is the one that you are raising, which is, will there be a report and will it see the light of day? I think there definitely will be a report because the special counsel rules require Jack Smith to write a report. Now, it does not have to be as lengthy as the Ken Starr report or the Mueller report. There's no requirement with respect to the length. It is also a report that initially is given by the special counsel to the Attorney General, in this case, Merrick Garland, in secret. That's required by the rules. So the special counsel has no power himself to make it public, but Merrick Garland does. I do think that Merrick Garland has signaled in the way he has treated other special counsel reports, Rob Hur to be precise, that he is certainly is a penchant for wanting those things to be public. The problem here is that there, at least with respect to the Mar-a-Lago case, there are two co-defendants who are the case is proceeding as to them. There is no request by Jack Smith to dismiss as to those people. Now, Donald Trump can pardon them. He can also just direct his Department of Justice to dismiss the case. But because there are these two co-defendants in the Mar-a-Lago case, any report that is made public with respect to that part of the case, the under investigation, the Florida case, will be severely redacted because they will not want to prejudice that criminal case against those two defendants, even if, as everyone knows, it is highly likely that Donald Trump will get rid of that part of the case.
So what do you think?
And so I think there will be a report. It will be highly redacted. As to Florida, I do think we'll see a report as to the D.C. case.